All right, Chapter 3, let's talk about the court system. This ought to get everybody excited. You know, if you haven't already been involved in the court system, at some point in your life you may well be. For good or bad. In some cases it may be to enforce your own rights, or it may be because you've gotten into some sort of trouble, or as in the case of the bank, you know, we often dealt with courts over different issues. I mean, even to foreclose or sometimes repossess property, you had to go through proper channels, right? And oftentimes those didn't even require visits to the court system, but sometimes they did. And also banks were common, especially when I first started. It was common for people to sue banks, and so we had to work through some of those things and visit court as a result. I don't know, you know, in my years in banking, though, I don't think that I was ever at the court itself or during a regular session of the court, you know, on behalf of the bank. You know, we did have, I'm trying to think. I don't think we ever had a trial that actually ended up going all the way to court while I was there. If we did, it was early on, and I was not a part of it. But in any event, I've said about that. Let's talk about the court system here. So, what do we do, right? Corporate governance. We have to have a court system. We got to be able to enforce contracts. We have to be able to, when there's torts, we have to be able to hold people accountable. We have to have some criminal law, right? We have to have laws against murder and stealing and those types of things, and we have to be able to enforce those, and we enforce those through a court system. So why study law in the court system? A manager, you know, even if you're not a lawyer, you got to have an understanding. Believe me, I learned a lot about our legal system working at the bank, and had to have a very strong understanding of certain laws, of course, banking-related ones, again, foreclosures, repossessions. A lot of those were on the back end, but on the front end, just the contracts, you know, the legal contracts that we did, the loans that we made and the contracts that we signed as a result of those, and the way we secured transactions or took collateral, basically, for those types of things is all an understanding of the law and how we protect our rights under the law. And, you know, and I tell folks, too, I probably talk to lawyers that at least once a week, business related. I probably talk to them more often than that because you get so you know a lot of them. But business related, probably at least once, maybe more often than that. And for me, it ranged anywhere, sometimes from some HR issues, because I was involved in hiring a lot of people, and unfortunately the other side of that, but also you know, the business side of things, dealing with customers, former customers, those types of things. Certainly I was involved as party as a witness. Again, not many went to trial, but deposed. I was deposed several times during my years at the bank, and even after I had left the bank, I was deposed at least once in regards to some matters that were still ongoing at the bank. And so that happens, you know, and occasionally I had to write up an affidavit and do some other things, and you know, it became a part of everyday life, and certainly at least weekly, you know, dealing with court types of things. So legal costs, right? Yeah, look at those ones, 50, 75 million. Those seem tiny when you think of, you know, the banks and the hits that they took following the mortgage crisis 2007, so just 10 years ago. You know, we've seen settlements in the, you know, Citibank, $7 billion, all the way up to Bank of America, $16.5 billion in settlements that were reached as a result of some of the wrongdoings that were found, that these banks were found to have participated in. So what do we have? We have judges, magistrates, and justices, kind of different names, and they're often different levels. For example, at Supreme Court, you have a chief judge, right? But everybody else is called a justice. So you've got, you know, actually you say you've got 9 justices, but one of those is also the chief judge. We have federal judges here in the state of Montana, 3, 4, 5 of them, I think, something like that. But there's also magistrates that are like assistant judges. They often take on cases that maybe a little minor, maybe not as thought-provoking or whatnot, or not as difficult to rule on, and so some of those cases will be assigned to magistrates. We do have a chief judge for the federal court here in the state of Montana, but his main duty is just to assign the cases as they come in. He takes some himself, he or she, I'm sorry, but then assigns the others to the other judges around the state. Okay. They determine the rules of law. Okay, they in a jury trial, they don't find guilt or innocence, but they determine the rules, right? How we're going to proceed, what evidence is allowed, and those types of things. They can find facts, and what that means is that judges can be, you can have a bench trial, it's called, or ask the judge. The defendant has that right to ask the judge to make a decision rather than a jury, and there sometimes are a lot of reasons to do that. Juries generally decide questions of fact unless we're having a bench trial. A trial judge renders a decision on a people conflict, which can mean civil cases and those types of things, but those can be jury trials as well. And again, I believe defendants in criminal cases have the right to choose, and I believe that's true in civil cases as well. I know at least in one case where the bank was sued, and it looked like it was going to go to court, and we asked for a bench trial, and actually received summary judgment in that case, so there actually wasn't even a trial. But the judge ruled on that, and we'd have asked for the judge to rule in a trial case, and our reason for that was kind of simple, that banks are always presumed to have a deep pocket. It would be very easy for a jury to be sympathetic to a plaintiff who felt they might have been wronged by a bank, and so we felt the judge would be a little less sympathetic, I guess, if that's the right word. So the judiciary has the power of judicial review. Basically, that means that they can review any law that's passed by legislatures, okay, or localities, be it cities, towns, counties, states, or federal. Ultimately, the judicial system can review those and determine the constitutionality of those. That's what the whole rule of law is about, that we deem that our written law is more important than people. Juror is a fact-finding body, or a petit jury, and we just refer to it as a jury, is generally for those trial cases. The two other types of juries are grand jury and coroner's jury, which we won't talk about at all because that deals with dead folks. But a petit jury is just a trial jury, right? The normal ones that we would think of. They're usually 12. There are some provisions in some states for smaller ones. They found that the decisions don't seem to differ all that much between smaller and larger groups that are in juries. In a criminal case, okay, beyond a reasonable doubt almost always means unanimous. Okay, and for our purposes, we'll say it does mean unanimous, right? Beyond a reasonable doubt is the criminal standard. Okay, it's the criminal standard of proof, and that means a unanimous jury. Okay, when you hear of a hung jury, that means that they couldn't come to a unanimous decision, and there might have just been one holdout, or two, or whatever, on either side. Okay, and so it's not unanimous, but it has to be a unanimous decision, either for conviction or acquittal or innocence. Okay, there are some provisions in some states for these to not actually be, but they still have to be supermajorities even in those. Like maybe they might allow an 11-1 or a 10-2 or something like that type of a decision to still allow for maybe a conviction of a person, and not have a hung jury. But I would guess those would be for less than capital crimes. Juries don't have to give reasons, or jurors certainly don't have to give reasons. So lawyers. God, we love to hate lawyers. Just absolutely love them, right? They have a duty of administration of justice, right? but they have a duty to defend their or to represent their clients, whoever those may be, right? And so they're advocates for those people. They're often required, remember, it says right in our Constitution, or in the Miranda rights, I'm sorry, not in the Constitution. Maybe it does say it in the Constitution too. God darn, I'm going to have to get out and read it. Anyhow, they're required, and remember, if you can't afford an attorney, one will be provided. Okay, that's part of your Miranda rights. That's part of the rights that we hold dear. So even if you can't afford an attorney, they'll get you one. And they serve as counselors, advocates, public servants. The public servant part is that usually they do have some requirement for doing some pro bono work. So doing some of that work that is, maybe for those folks that can't afford it, sometimes they'll be called upon to represent those folks. We've all heard of lawyer-client privilege or confidential communications. So they're required to keep those confidential, even if they found out in conversations with you that you were guilty as hell. They're supposed to keep that. They're not supposed to go tell the judge that. They're supposed to keep that confidential. So with lawyers, right, our system is adversarial. So we pick sides. That's basically all that means, is we pick sides and we go at it, right? I'm representative of combatants. Wow. Pick somebody to go to bat for you, go fight for you. It's kind of true. If you're gonna go to law, you want somebody that's definitely gonna be your advocate, somebody that's gonna stick up for you and your side. So lawyers present evidence. They present to the judge points of law and whatnot, and they make arguments. Okay, and as we pointed out earlier, they function as a counselor, an advocate, and a public servant. Well, let's stop there, and we'll do another one when we get to the court systems.